Our last case today will be Van Buren Charter Township versus Visteon Corporation.
Justices of the Supreme Court, good afternoon. Kaveh Kashef appearing on behalf of the appellant, Van Buren Township, sitting at counsel's table with me, my co-counsel, Patrick McCauley. Your Honors, absent reversal of the Court of Appeals opinion, that opinion will effectively dismantle the purpose and the benefit to the people of the state of Michigan of the declaratory judgment rule and effectively make it a nullity. What the Court of Appeals has done in its opinion is it's created a standard that is far too great for the people who want to come before the trial courts of the state of Michigan to bear. And for the township specifically that I represent, it has created a burden in that it must first endure a multi-million-dollar financial catastrophe, according to the trial court and the Court of Appeals, before it can come to the court and to have the adjudication of a true controversy between the parties. First, the declaratory judgment claim is clearly ripe. There is a dispute between the parties, Visteon and Van Buren Township, regarding the interpretation of this agreement. We believe that there is an obligation on the part of Visteon to negotiate and make payment in advance of a shortfall. Visteon disagrees. The consequences of this disagreement are, in about a year, there will be an obligation on the part of the township to make payment, and when it turns to Visteon and says, will you abide by your contractual promise, Visteon will say no. That is what they have been saying up to this point. That is an actual controversy that has been pled by the township. And recall, we are at the initial pleading stage when this case was dismissed on ripeness ground. On the breach of contract claim, the claim is ripe. We have alleged and actually have also supported evidence that demonstrates that unequivocally Visteon has stated no matter what happens, if we negotiate before, during, or after a shortfall, we are not going to pay anything. Or if we're going to pay anything, it's de minimis. And it's relevant that it's a de minimis position compared to a $30 million obligation. That is a controversy. The courts of the state of Michigan have indicated ripeness exists the moment an anticipatory repudiation occurs. That addresses the first question that this court asked when granting a MOA. The second question this court asked was whether or not the Court of Appeals correctly interpreted the contract. I read this, it did not, for two reasons. First of all, the standard that the Court of Appeals used when interpreting the contract was a merits analysis. This court has repeatedly stated that justiciability issues such as ripeness are threshold issues. And the Court of Appeals, in ruling that this case was not ripe, went to pains to reach the conclusion that its interpretation of the contract, not the trial court's interpretation, but the Court of Appeals' interpretation of the contract, justified dismissal and that the claims were not ripe. In light of that error, the court should reverse the Court of Appeals. When you look substantively at the analysis that the Court of Appeals engaged in, substantively, its position is untenable. The Court of Appeals said there is no other reasonable interpretation other than its interpretation. I submit there's no other interpretation than the one we suggest, which is you cannot read the word timely out of the agreement. There is a clear sequence in the agreement. First, and it's in the words of the sentence, you negotiate and pay, and then the township makes a timely payment. In order for the township to make a timely payment, they must receive the money from Visteon first. Otherwise, it's not timely. Furthermore, what would be the purpose of negotiating everything if we knew what the shortfall amount was? It totally renders the terms timely and negotiate a nullity.
Counsel, I want to. Can you help me with what exactly the relief is that you're seeking and how that relates to this ripeness question? I think in the lower courts, you wanted a declaration that Visteon was responsible for the entirety of the shortfall, but now it seems like maybe you want the court to order Visteon to negotiate? Does one or the other matter in how we think about the ripeness question?
I think both issues matter, actually. And what we're asking for...
What are you asking for? And then tell me what...
What I'm asking is for the court to peremptorily reverse the Court of Appeals and issue an order that states that, A, both causes of action, the Declaratory Judgment Act and the breach of contract claim, are ripe. And the breach of contract claim has two components to it. First, that they failed to negotiate, and second, that they anticipatorily repudiated. Declaratory judgment cause of action has multiple components to it too. First, that they should negotiate, and second, that when the time comes to pay, they should pay the entirety of the shortfall. That's our position. The other thing we're asking from this court, because the court asked the question. The court asked the question, was the interpretation of the contract correct? The court asked the question, I will answer it. It was not correct. And this court has enough before it to reach the conclusion that, in fact, there is an obligation on the declaratory, there is an obligation on the part of Visteon to negotiate in good faith with the township and then make a payment in advance of the occurrence of a shortfall, which is going to occur in October of 2019.
The parties haven't yet even litigated what the obligation might be, have you?
Well, we have not litigated. There is a dispute. We think that our position is correct, but this goes to the question of there is a controversy for the parties to litigate. Now, because this court asked what is the correct interpretation of the agreement.
You're not asking us to determine what the obligations of the parties are under this contract, are you, at this point?
I am, because the court asked the specific question of whether the interpretation was correct, and I am submitting to this court what the correct interpretation is. Now, this court can take it upon itself whether or not it wants to reach a ruling on that. The principal argument, of course, is a ripeness argument, and whether or not...
It's a separate question when that obligation, whatever it might be, when that obligation is triggered, right? That's a separate question. Do you agree?
Separate to what other question?
What the obligation is. There's two things. Isn't your theory that the Court of Appeals error was that it not only said that the controversy wasn't right, but it went further and actually interpreted the contract after determining that the controversy was not right?
Correct. And I do agree those are two steps in the sequence. First is whether or not the controversy was right. The second is a merits-based analysis and the interpretation of the contract that normally would, in fact, be reserved to the trial court to ultimately decide when a ripeness adjudication was reversed in this case. I do also add to that, only because the court asked the question, that this court could interpret the agreement that's in front of it and also reach the conclusion that no reasonable interpretation can be achieved other than the timeliness and the negotiation require that that occur before the shortfall occurs. And I don't think what we're asking for from the court is revolutionary. What I think is revolutionary is that over the course of the last several years, as it relates to the declaratory judgment rule, courts have been kind of going back and forth. And I think where this court should go in terms of setting a jurisprudence for trial courts starts with Lansing. We cite to Lansing frequently in our briefing. We believe that Lansing, as applied to standing, should be what guides this court as applied to ripeness and all justiciability doctrines. Too many courts are relying on Michigan Chiropractic and Associated Builders and the language that's contained therein. However, those cases were effectively overruled by Lansing. Courts are forgetting that justiciability issues are threshold issues. They are not constitutional issues. As recently as after the Court of Appeals, again, a published opinion, issued its opinion, there are Court of Appeals per curiam opinions that are stating that justiciability issues remain constitutional issues. They're still getting it wrong.
That's not such a frivolous argument, given that they are in the federal system and they were in the state system until Lansing.
Your Honor, I understand what the court's position was in the dissent in Lansing schools, but I also understand that, Justice Markman, you've joined in the concurring opinion in People v. Richmond. In People v. Richmond, the court stated on the issue, I believe, of mootness, that is a threshold issue. And that was what you concurred in. Now, whether or not the Lee line of thinking was correct or the Lansing schools line of thinking was correct, obviously people can disagree on that. It is the law of the land. And it doesn't really make a huge difference in the context of this case, where ripeness has been achieved. That under the threshold analysis, not a merits-based analysis, but under a threshold analysis, ripeness has been achieved, that a controversy exists both in terms of the breach of contract claim and the declaratory judgment claim.
But we have said that the injury or right in question can't be speculative or excessively hypothetical. Isn't that precisely the problem in this case? Your cash flow analysis is a mere projection, and it sets forth, I think, more than a dozen, maybe as many as 15 different possible shortfall figures.
Yeah, and that is what the trial court and the Court of Appeals keep hanging their hats on, but that's not actually correct in terms of the interpretation of the report.
Some of us don't continue to hang our hat on the wrong thing.
That's all right. Let me clarify that. The PFM report, which was a preliminary report sent concurrent with a demand to negotiate, it wasn't a formal expert report at trial. It was something we attached to our complaint to demonstrate a case or controversy existed. That report has 15 scenarios that reach the same conclusion, that there will be a shortfall. Back then, in 2018, there was one scenario that said 2019, but the numerosity of the scenarios supports the imminence of the harm, that by manipulating various variables regarding the amount of real property taxes that come in, you still reach the conclusion of an inevitable shortfall. That helps the argument. The argument that Visteon made is that, well, there are a number of things that could happen between now and 2018.
But let me ask you, are all shortfalls alike? Are
Yes.
all shortfalls fungible, or does it really depend? Is it a function of whether or not the shortfall is or is not attributable to defendant's property taxes to a greater or lesser degree?
That is the only source of revenue to determine whether or not there will be a shortfall. I'm glad you asked that. Let me clarify that there is only one source of revenue. Real property taxes captured within this designated LDFA district, which is a small subset of the entire township, and it is the area where the Visteon Village was created. This is no different than a loan. Bondholders issue a loan to the township for the construction of Visteon Village. Our payment obligations are set till 2032. That will not change. 2032 is when the last payment obligation has to be made. On the other hand, you have revenue coming in, and they can calculate using these multiple scenarios how much revenue is going to come in and compare that to the payment obligation and determine when there's a flip in terms of the payments being sufficient, the real estate payments being sufficient to meet that burden. Under the PFM report, they made it unequivocally clear that absent some kind of significant event, and we've described the construction of a stadium, because that is exactly the amount of revenue that would have to come in. There will be a shortfall. It's inevitable. And all the law requires is that we demonstrate that a harm will occur and that it is imminent. Now, imminent lies in the eyes of the beholder. 2032 is the back end of the obligations under these bonds, and we say 2019 now is when that shortfall will occur. It's clearly imminent. On the other hand, it is Visteon that is trying to throw contingencies into the mix. We don't know what can happen between now and the date of the shortfall is their position. That's a contingency. When asking Visteon, what do you think could happen between now and 2019? Is there someone going to build a stadium to create enough tax revenue to avoid the shortfall? They have no answer. Of course, these are questions of fact with regards to the obligation, whether or not the PFM report is in fact an expert report that is unchallengeable, though given the opportunity for 2 years, Visteon never came up with a counter report.
Can you clarify what you mean, what was meant in the agreement by the following language, too, in light of what you've just been sharing with the court?
Yes.
The agreement itself states, to the extent that the property tax payments made by Visteon to the township are inadequate to permit the township to meet its payment obligations with respect to that portion of the bonds that were used to fund the village. Doesn't that suggest that it's less than totally clear that that the entirety of the shortfall would be attributable to Visteon's inadequate property taxes?
Is the question you're asking regarding that portion of what you stated that states that were used to help to fund the village? Is that the part you have a question about?
That's right.
Yes. if it's a question of fact regarding contract interpretation, the court knows what needs to be done with this case. That it is not clear and this case should proceed on the merits, and that's not a ripeness issue. But no, I don't think there's really confusion as to that issue because the parties...
The language at least suggests that any shortfall is not necessarily attributable to the deficiency in defendant's property tax revenues.
No,
At least it raises that implication, doesn't it?
Well, the court's misunderstanding what that language means. So, in other words, in the context of these bonds, the bonds that were issued, it was approximately $32 million, they need to be used to fund the, for public benefit. There's no question of fact on what those monies were used for, that those monies were used for public use.
Not all of the bonds were used to pay for the village.
Oh, yes, they were.
They were. Well, so what does it mean that it says with respect to that portion of the bonds that were used to help fund the village? That
Well,
implies some portion of the bonds was used for another purpose, doesn't it?
No, I think what they're saying is that in order, they're actually clarifying, and I didn't draft this document, but what I believe that the drafts people indicated when they were doing this is they wanted to make sure that there was a reference to the fact that the bond money was used to pay Visteon Village. Now, to the extent back then in 2010 when this agreement was drafted, there might have been any question whether all $30 million was used for infrastructure improvements and so forth. I don't know. That's never been an issue that's ever come to light in this case, is that issue regarding how much of the bond money was used for public versus a private purpose.
Well, let me cut to the quick and one final question on my part. Are there alternative sources of revenue that were intended to be used to pay off the bond service debts here?
No, there are not. None. There are none within the LDFA. If, in fact, a shortfall occurs, what will happen is the township. So the LDFA and the township are two different bodies. The LDFA is a creature of statute that was created for the sole purpose of this development. If the LDFA has an insufficient amount of tax revenue, absent Visteon stepping up and doing its contractual duty, the township has an obligation because it pledged its full faith and credit, which is very, very normal in the issuance of public municipal bonds. Its pledge of its full faith and credit will require it to avoid a default to use its general fund dollars until they're depleted. Those dollars which are earmarked for public services, for fire, rescue, police, for parks and senior citizen centers and just rainy day funds will have to be used till depletion. They will get depleted. There is an insufficient amount of money in the bank account for the township. It will get depleted. It will result in a default, which will result in an acceleration of millions of dollars of debt. So the backstop to the LDFA, to answer your question in short, is the township and its bank account, unless Visteon does what it promised it would do.
Thank you, Mr. Kashef. Are there any further questions? Thank you very much.
Good afternoon. Excuse me. May it please the Court. Philip DeRozier, appearing on behalf of Visteon Corporation. We think that the focus on whether ripeness is constitutional or prudential is at the end of the day misplaced because in our view the analysis is the same. Even after Lansing Schools, the Court has recognized that ripeness principles require, as Chief Justice Markman recognized, that a claim not be contingent or hypothetical. We cited the Court to the People v. Corp case, the Charter Township of Herring case. There are opinions from the Court, even after Lansing Schools, recognizing that that's the essence. Not contingent, not overly hypothetical. And in fact, that's also the essence of the actual controversy requirement of Rule 2.605A1, which the Court has said time and again, before and after Lansing Schools, that it's to prevent a court from deciding hypothetical issues. So here, we think that the Court of Appeals properly determined that a declaratory judgment isn't ripe because the parties' rights and obligations under the settlement agreement can't be determined until there's an actual bond shortfall. And I think it comes down to the express language of the settlement agreement, which provides if Visteon's property tax payments are inadequate to permit the township to meet its payment obligations, and with respect to the portion of the bonds used to fund Visteon Village, and that is important because it is not clear the extent to which the portion of the bonds were used to actually create the village. That's why the language is in the settlement agreement. You have to give it its plain reading. Only then is Visteon required to negotiate the amount of the shortfall and potentially make this pilot payment that's referenced in the settlement agreement. That's the language that the parties agreed to, and it makes Visteon's obligation even to negotiate, let alone to make a payment to the township, contingent upon the occurrence of an actual shortfall. Now, the township has claimed that a shortfall is inevitable and that it's going to occur as soon as, I think, October 2019 is the latest that we've heard. So not only is that speculative in our view, but again, Visteon's obligation to negotiate hinges upon whether its tax payments, again, going back to the language of the settlement agreement, whether they are inadequate. As the Court of Appeals pointed out, that is present tense language. It doesn't say may be inadequate or even will be inadequate. It requires an actual shortfall. And there's also been reference to the notion that, well, there's language in the settlement agreement about assisting with a timely bond payment and how the township can't make timely bond payments without having the negotiations over the shortfall done ahead of time. The first problem with that is that it's speculative to suggest that a payment by Visteon after the occurrence of a shortfall, then there are the negotiations that are supposed to take place and a payment is made. It's speculative that that wouldn't timely assist the township. The township has to make payments under the bonds every 6. Yes, Justice.
Counsel, good afternoon. First off, welcome to our first day of session. And
thank you.
I just have to ask, in terms of the contract, when looking at the contract, isn't the contract, the idea of negotiation in and of itself part of the contract?
The contract does require negotiation at a certain point, yes.
But so isn't that in and of itself a negotiable component which by its nature would make the case ripe for a case in controversy? Because the idea is, well, you've agreed and the parties have agreed that there would be a negotiation. Is your failure to negotiate ultimately a conceptual notion that would ultimately make the case now controversial?
I don't, Your Honor, I don't think so, and here's why. I think the problem is, again, because of, and I understand that the township's position is as well, that's a merits determination, but I do think that even in determining whether a case is ripe, when you're talking about a contract dispute, it's necessary to take, at least an initial look at that language to see whether there really is something here for the court to be able to decide. And here, where this negotiation, and I understand there's the claim that Visteon hasn't negotiated, but again, where the contract says the negotiation obligation is, it's a timing issue, it's contingent upon the occurrence of a shortfall, I think that's why, even though there's a claimed dispute about whether or not Visteon has negotiated, the fact that the parties' agreement says that it's in the future, that's what makes the case not right.
But isn't that in and of itself a question to be determined? Like, we're not talking about who's going to win or who's going to lose. We're only talking about whether or not you can bring an action. So your position would be that that component of the contract isn't sufficient enough to have a question of fact?
Well, in short, yes. And I think the other thing that's important to keep in mind is that the purpose of a declaratory judgment isn't to, in my mind, to pick isolated things out that maybe theoretically that issue could be addressed. At the end of the day, you have to ask yourself, well, what was the circuit court supposed to do here? It takes this case. Even if there's a part, even if there's a dispute over whether the obligation negotiated is now, if ultimately it doesn't advance the ultimate disposition of the case, I think that then that's a reason why a declaratory judgment action isn't yet right.
Can you help me understand that? You're saying even if it was ripe and there was an obligation, what is the circuit court supposed to do? I guess you lost me on that point.
Oh, I'm sorry, Your Honor. So the point I was trying to make there is a ripeness determination in connection with asking for declaratory relief. It's more than just deciding or looking at whether there are isolated things that maybe you could pull out and decide. You have to look at it in the big picture. What's the declaratory relief that's being requested such that can
their position is you have a contractual obligation to pay the difference, right? Make up the shortfall.
Right, but I guess my attempt to answer Justice Bernstein's question was just to say that the whole thing has to be subject to issuance of a declaratory judgment that would resolve the case. Otherwise, because the whole point of a declaratory judgment is the court isn't supposed to issue a declaratory judgment or consider issuing declaratory relief unless it's necessary unless it sharpens the parties' relationship and the issues in some way that advances the ultimate disposition of the case. If we were to go back down to the circuit court, with an argument about, well, do we have to negotiate now? Well, then there's a whole other part of the case that's still hanging out there that isn't right, because what are we supposed to negotiate over at this point when we don't know when
isn't it all you're bootstrapping it all together, aren't you? I mean, the whole point is there's a dispute about what the obligation is, right? But you're saying
Yes.
unless the circuit court. The circuit court eventually would have to determine what the obligation is, right?
Well,
if it determined, if we were to disagree with the Court of Appeals, say that it's ripe, if we were to look at the language of the contract where it says timely and say that if there's an obligation, the obligation is to do something before the shortfall, then it would go back and say, what's the obligation? What would be wrong with that as a disposition of this case?
Well, because until there's a shortfall, there's to order or to declare an obligation to negotiate. It doesn't
now
serve a
you're
purpose.
wrapping it all up together again. It
I
sort of
think
bootstraps it. But let me ask you this: are you saying that actuarial, no one could ever determine whether there's going to be a shortfall in the township's ability to make this bond payment that's due next year? You're saying that can never be known in advance? We just have to all wait with bated breath, and if the day passes and they don't write the check, then there would be a controversy?
Well, yes, Your Honor. What I'm saying is that until there is, again, this is the agreement that the parties reached, that until there's a bond shortfall.
The language is not great, right? So both parties, I don't know who drafted it, but the language is not great. It'd be a much easier case if it was clear.
But what the agreement...
But my question is, you're saying we can't... let me ask you this. For declaratory judgment, we've said, in the Shavers case, court's not precluded from reaching issues before actual injuries or losses have occurred, right? In a declaratory judgment action.
That's true.
Why is this not that situation? The injury hasn't occurred. They're telling you they have very good reason to believe that an injury is going to occur. The language of the contract says, assist the township. I'm not sure what assist means, but assist the township in making timely payment. I know what timely means. That means before they're defaulted, right? Before they're due, or on the due date at least, right?
Well, but that's part of the problem in terms of what makes everything here theoretical is that the timing of the default, the timing of when the payments are due, because again, these are payments that are due year after year, twice a year, depending on the winter and summer taxes. So there are a lot of moving parts here that go into applying this language in the settlement agreement, and that's exactly why I understand you're saying that I'm bootstrapping, but I think that's really the problem, is in order to have this dispute over what are Visteon's obligations with respect to a shortfall, what payment, if any, has to be made, those determinations can't be made today. And certainly nothing in the agreement says anything about, well, Visteon's payment obligations can be based on an estimate after experts, theorize and come up with different scenarios of timing of shortfall and amounts of shortfall. That's the
but
agreement.
It does say timely payment on the bonds, and that would imply that somebody would have to estimate something, wouldn't it?
Well,
if you're going to help them make a timely payment.
But that can happen but we'll know when there's a shortfall what we're dealing with.
But that wouldn't be very timely, would it?
Well, there's a difference. There's a difference between when the shortfall occurs and then when the payments on the bonds are actually due. And like I said, if nothing else, it's something that's just, it's not known right now.
I mean, and there's some tension, right? Because the language, and we're not here, I don't think, to answer the ultimate question of what this obligation might be, but there is some tension in the language where it starts off to the extent the property tax payments are inadequate, that to the extent language implies something, I'm not sure exactly what. And on the other, at the end of the clause, it says to assist the township, and I'm not sure what assist means. But I don't disagree with you. There's different ways to, I think, interpret the language. It seems to me something that the trial court would have to work out. But the point is, I suppose, from the township standpoint, if there's an obligation at all, well, isn't it something that has to be determined before the default?
Well, the way that we look at it is that may be a certainty that they're asking for, but that doesn't make the dispute.
Well, it's not just that, it's the language here, this timely payment of the bonds. Tell me why they're not entitled to that, based on that language. Why am I stuck on that language and thinking that if there's an obligation, I'm not sure what the obligation is. I don't think, frankly, the issue's been sufficiently litigated for our court to even come close to making that determination. But if there is an obligation, it's something they're entitled to begin enforcing now if they're going to have a timely payment made before the default. Why am I wrong?
Well, because you're assuming that you're assuming that the language entitles them to that.
I'm not assuming. I'm telling you that's how I'm reading the language. I'm interpreting. Why am I interpreting it incorrectly?
Assuming that the only way for them to get timely assistance is for everything to be estimated before an actual shortfall.
Tell me another way.
Well, again, because the record is undeveloped as far as when exactly is the shortfall going to occur and what happens at that moment in time relative to then the parties negotiating over the amount of the shortfall. And
you agree the payment would have to be the assistance in form of a payment from your client would have to occur before the default? Sometime after the shortfall, but before the payment is defaulted?
I guess, yeah. I think that's the question, though. Is when is the default relative to the determination of when there's going to be a shortfall based on the tax revenue? Yeah, I think that's a question. But again, I guess in my mind, it all goes to exactly why the trial court and the Court of Appeals determined that this isn't ripe yet. There are all of these questions that are hanging out there, none of which can be answered until there's an actual shortfall. And that's in the minutes.
I understand it, then there's a shortfall that's yet to be, but even after there's a shortfall, there's some period of time before the payment is due in order for it to be timely. We don't know if it's a week, a day, a month, several months. That's
what's unknown. Right. That's what I'm saying. You can't assume that timely means at the time of the shortfall. We don't know what the lag time in there might be.
Isn't there a payment due date? Like you got to make a payment, like my credit card company says, if you don't pay your bill by this day, you're defaulted, you're untimely?
There may be. I can tell you it's not part of the record as far as I'm aware. This exact question of timing. And so again, I think what then the Court of Appeals.
There's nothing that's part of the record because according to counsel, we're just arguing about the pleadings at this point, right? So you're saying it wasn't alleged in the complaint?
Correct. Well, yeah, the relationship of this timely language wasn't developed in the complaint. And so what we had was we did have the complaint, but we had more than that. We had the complaint, we had the expert report, we had we had the settlement agreement. So we had more than just the face of the pleadings. But I think what still ultimately becomes the problem is when you look at the language of this settlement agreement as a whole, and I acknowledge this question about the timely. Honestly, I don't know exactly what that means. But what I can say is that the rest of the agreement talks very specifically in the present tense about all of these things taking place upon the occurrence of an actual shortfall. And so I don't think you have to, in order to either deny leave or to uphold the determination that this case isn't ripe, I don't think you have to have anything more, frankly, than the language of the settlement agreement.
Are you contesting the notion that you have an obligation to negotiate with the township in good faith to determine the amount of the shortfall?
Once, in the event that the shortfall occurs, in the event that Visteon's tax payments, again, going back to the language of the settlement agreement, are inadequate. So we don't know.
I'm very confused. So how would you know they're inadequate if you don't negotiate to determine the shortfall if the shortfall has to happen before the default? So you wait till the default and then you negotiate?
Well, we know the shortfall will happen when, in fact, there isn't enough revenue from the tax payments to cover the bond payments. I mean, that's a certainty. That if that happens, it will happen. So all I'm saying is that until that happens, until there actually is a day or a period, whatever that period is, when the tax payments aren't sufficient to cover the bond
That's
payments.
not something that can be known in advance, a minute, an hour, a week, a month.
That's not something that can be known beyond the hypothetical and conjectural realm, would ultimately be our position, and that's, where we think the trial.
Doesn't your client know what its tax obligations are for 2018 or 2017 or whatever the relevant time period is?
Well, there are lots of other, it's not just that, right? It's also the revenue coming into the LDFA district. I understand and I look at this as kind of more speculation. Well, we'd have to build a professional sports stadium in order to bring in enough revenue. I don't know whether that's, I can't even really address that because it's not, it's not part of the record. It's just an assertion. What I can say is that the things that can happen as demonstrated in the PFM report is there are sources of revenue, there are returns on the township's investments, there are, I know the township says, well, we can't refinance anymore. That, again, is not part of the record. That's the township's assertion that can't happen. The point is that the prediction of a shortfall, as evidenced by their own expert report, is something that it can only be estimated at best.
Just so I'm clear, is it your position that the township has to default on the bond obligations before your obligation to negotiate the shortfall is triggered, or am I not hearing you correctly?
No, I'm not saying that. What I'm saying is I don't know when the township will be in default.
What triggers your obligation to sit down with the township and determine the shortfall?
When the payment when the payments, the property tax payments from Visteon when they're capable of being determined to be inadequate to meet what the current payment obligation.
Isn't that what they think is today? That's right now? That's the report they attach to their complaint?
Well, they're not saying it's today. They're saying it might be in a year. But
You said when you're able to calculate it.
Well, but right now it's still just a future projection. You asked me, and maybe I misunderstood the question.
I'm trying to figure out, can you do this looking forward, or is it only in the rearview mirror? Is it a look back? Are you saying it's only after default and we look back and then we can hash it out with the accountants and figure out? Or are you saying at some point we can still do it looking forward, but just not this point? So what's the triggering point? What's your position?
I'm saying that the triggering point is what the parties agreed to, and that's when the property tax payments become inadequate for the township to meet its payment obligations. They're saying that's going to happen down the road, but the problem here was that the township never said that's the problem.
Has become inadequate the same as default when they default, or is it a different point in time?
It may be the same thing, Your Honor. I'm not sure. What I'm saying is that you asked me, is my position that they have to default first?
I mean, it sounds like your position is you have no obligation under this agreement to do anything
until there's a shortfall. And I know we keep retreating to that position, but I feel like that's all that we have is the ability to look at what the parties agreed to, and with everything else being hypothetical and conjectural. I appreciate an understanding of a want to plan, but I just don't think that's what declaratory judgments are for.
unless the parties agree to do something ahead of time.
If they agreed to do something ahead of time, sure, but I guess it comes down to what did the parties agree to?
Well, you've summed up the case correctly.
So I don't mean to belabor this, but I'm still confused. I still don't understand. I know you've gone back and forth with Justice Viviano, but I still don't understand the answer. I don't know what the trigger point is. Like, how do I write? If I were to write, let's just say hypothetically, I wrote an opinion that sided with you. I mean, I know we have the Court of Appeals. I know all that. I'm still confused as to what I would write. Let's say you won, right? What do you want? I'm still unclear as to what the trigger point is. When this all happens? At what point we have to give jurisprudential kind of counsel to the lower courts. Can you give me a straight, very simplistic answer as to at what point and I have a feeling I know what you're going to say, but try to make it more simplistic. At what point would the township have the right to bring forth litigation? And I know besides you're going to probably say when, I get all that.
No,
I'm trying to understand, like, when would that be?
Here's how I'm going to answer that, and I'm not going to just harken back to the language. I think what I will say is I don't know when that is, but they are the plaintiff, and they have to demonstrate that there's an actual controversy. And if there isn't one, when there may be down the road, I don't think that's something that you need to worry about for purposes of this case. The question is whether in the allegations, is there a ripe dispute? And here the complaint incorporates the contract.
But what we do have to worry about is, in a jurisprudential manner, how this affects the entire state. So when people can bring litigation is quite imperative, because when we write a decision, it's not just going to affect this case, it affects the definition of ripeness and when a case or controversy actually does arise. And so I'm just still unclear I mean, you're basically saying, let me make sure I understand your position. Your position is, you can't bring it now, but I can't tell you when you could bring it. That's basically, is that your position? Your position is, can't bring it now, but I'm unable to give you a roadmap or tell you at what point you should be able to bring it.
Well, the answer to that is yes, but to your point about providing guidance, I don't think that this case is a good case at all to provide guidance about when disputes become ripe. The other thing is that the court's opinions are already well established in terms of what the ripeness test is. I mean, the thing I think I've certainly learned about ripeness, and I sense that the court is obviously struggling with this, is applying ripeness principles to a particular dispute can be very tricky. But I don't think that leads to a concern about, well, how do we write an opinion here to give guidance just because this case is tricky. I think...
No, but it does, because here's the thing, is that we're fighting over ripeness, there are real people who are affected by this. If there's a shortfall, it doesn't become hypothetical anymore. There's actual government services and people and programs that are directly impacted by a shortfall, not to mention the city's credit rating and their ability to borrow in the future. I mean, there's actual real significant consequences that arise out of this for the people of that community.
And that I don't disagree with that the claim is that there are these potential consequences, but of course
but they're real consequences. I mean, so your argument is that, look, I know you've gone back and forth with Justice Viviano on it, but where I'm very concerned, and what gives me cause for concern is that at a certain point things don't become hypothetical. And we can have an academic discussion and we can discuss this in the abstract. But at a certain point, Van Buren needs to be able to borrow money. They need to be able to have a good credit score. They need to be able to do these things in order to maintain a city, to maintain a community. And if they're not able to adjudicate this or know how to plan their budget, just like what you're arguing, your client isn't able to do this for the future, they don't know. Are you going to lay off firefighters? Are you going to lay off police? Are you going to close schools? I mean, these are real people that are going to have real effects if this isn't able to be adjudicated at the appropriate time. So I guess I'm going to go back to the question that we've gone round and round on. At what point is the court able to get involved in this to try to stem the real harm that's going to come out of this?
Well, let me try it this way. I think in this case, as soon as the court has a dispute in front of it that goes beyond just, forgetting about what the parties agree to, we have this concern about our financial issues that the township may face. It's the determining ripeness is more than just that hardship claim. There has to actually be a dispute that's before the court that is subject to issuance of declaratory relief. And here, that's what we think is missing.
Does this put you, and this is my last question, I promise, does this put you, ultimately, is this in fact, this ripeness discussion, is this in fact a trial strategy? Like, can we almost look at this as though your argument to say it's not right is ultimately a strategy that the company is ultimately using to put the township in a worse off situation when they do default? So the idea being that if you're closing schools, you're laying off, you don't have a fire department, you don't have police, you don't have the kind of things, isn't this in a way your ripeness argument? Could one infer or interpret the idea that this is a litigation or strategy, that it's not really a ripeness question, but it's ultimately going to put the city into a position where they're weakened after the default takes place because they won't have the ability to negotiate an equal playing field? Due to the desperation that they're going to be in if we affirm the Court of Appeals.
I don't think that's a fair way to characterize the Visteon having raised the ripeness issue, and I think that the best evidence of that is both the trial court and the Court of Appeals looked at this and struggled with what are we supposed to do before an actual shortfall. And I understand there are difficulties in this case, perhaps determining when there is that actual shortfall, but again, it is what the parties agreed to. And so I think that where you have the trial court and where you have the Court of Appeals look at this case, and all the judges who have looked at it so far have asked themselves, well, we don't know what relief can be given here until there's a shortfall. I think that is what I would say is shows that the problem with the ripeness.
I have to apologize to my colleagues, but I do want to just try to put this in my own words and see if I'm even approximating what you're saying, because I share the confusion of the two colleagues who've most recently spoken. You're saying, as I understand it, there is some time in advance of the actual shortfall that the circumstances and unpredictabilities and uncertainties of the situation have become sufficiently stabilized to transform an environment of speculativeness and hypothesis into a sufficiently ripened environment in which there's an actual case or controversy. Am I approaching what you're saying? Or am I just if I'm totally missing it, fine. I'm probably not alone on that yet.
No, and I apologize that I have obviously not been sufficiently clear. And maybe it's because it's my own personal struggle with the ripeness issue here. What I am not.
What did I say that was wrong, though?
It's just the part about that there's a possibility of it being ripe before there's an actual shortfall.
Well, that's right. That's exactly what I intended to communicate.
Yeah, and that's the part that I'm struggling with. I don't see how, given what the parties agreed to here, you can have a ripe controversy.
Even if there's no uncertainties or question marks or things that remain to be resolved because it's 10 minutes away as opposed to 10 months away.
I would, Your Honor, because I don't want to be difficult over something that doesn't seem to be necessary. I think if you had in a theoretical world that level of certainty, then I suppose that's a possibility, because I acknowledge that the declaratory judgment cases, clearly they recognize that you can have an impending harm that's serious enough, and you can have the legal issues in the case be sufficiently able to be. But
it's like a mathematical limit. As we get closer to the shortfall, closer to D-Day, hopefully things will move in a predictable fashion, and we'll be able to predict, albeit with increasing certainty, what's going to happen at the moment of shortfall.
Yeah, the only thing I would add to that is the problem is it's not just the timing of the shortfall, it's all of the other things that go with it. It's the part of the shortfall that's attributable to the portion of the bonds used to fund Visteon Village. It's the amount of the payment that has to be made. And that was the point I was trying to make very early on about how I don't think you can isolate just isn't there an obligation to negotiate now? Because all of those other things, determining amounts of payments, pilot payment, those things, we are not in a position to be able to do that. And the other thing is, it's not as though there haven't been negotiations.
Okay. You've gone through a lot here, and we appreciate you too. Thank you very much, and we'll stand in recess till 9:30 tomorrow.